Hello, everyone, and welcome to One Civil Law. I hope you're having a great day. And for today's stream, I saw this video in which a judge is dismissing a life felony charge from the prosecution because the prosecution isn't playing nice with discovery. The prosecution has not been doing their due diligence, and the judge is like, screw you. I'm dismissing this because the Constitution is still a thing. I'm here for it. Let's get started with this.
This is docket, I'm sorry, this is Anthony, yep. And there's two, are there two files? I only have one listed. Is the final pretrial on both or on one?
It's just on the one, Your Honor.
All right, thank you. This is docket 23131 FC, People of the State of Michigan versus Carlos Lee Anthony. Counsel, your appearances for the record.
Good morning, Your Honor. Michael Doby, P76671 for the people.
Thank you.
Good morning, Your Honor. Ronald Berry appearing on behalf of Mr. Anthony, who is standing to my left or right at the podium.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide you the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
You put your hand down. Thank you for wearing a suit. I rarely see defendants wearing suits, so appreciate that. Okay. Have you taken any medication yesterday or today?
No, ma'am.
Alcohol, marijuana?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
You had no time to talk with your attorney?
Yes, ma'am.
And has there been a plea offer in this? This is a final pretrial.
There has not been, Your Honor, in discussion with the defense attorney.
Sorry, sir. You need to stay closer to your mic. I can't understand you.
I apologize, Your Honor. No, there has not been a plea offer made in this case. In discussions with the defense attorney, it was made clear that the defendant would only accept a misdemeanor, so there was no real negotiation beyond that.
Counsel?
First of all, I don't discuss the subjects of our negotiations. We had a conversation. I don't know that I ever said that he would accept any offer, let alone whether it's misdemeanor or felony in this matter. He maintains his innocence, and we've negotiated as such. Where we're at right now is Mr. Doby had indicated to me 3 months ago that he was going to follow up with law enforcement about getting discovery that's outstanding, and I haven't heard anything since. We don't have the body cameras, the motor vehicle camera videos, anything of that. I understand this is the AG case was transferred to AG's office for William County.
Wait.
But this whole we don't have it.
Stop a minute. This is a 23 case. Sir, how is it this information has not been given to counsel? 2 years, 3 years. What's going on?
That's a pretty good question, right? This is a life felony case. It's a 23 case, meaning it was filed in 2023. It is now 2026. It's been a hot minute. How is it that counsel is not gotten this discovery at this point? Good question.
What's going on here?
Your Honor, a lot of the things that he has requested simply don't exist. 4 body cam videos were located by a subsequent search by the detective sergeant now
A subsequent
on the case.
You have to stay next to the
has now-
microphone. So you said a lot of what he's requested doesn't exist. And then what did you say?
4 additional body cams that had not been previously provided to my office were provided. They have been provided via a download link to Mr. Berry this morning.
Via what?
A download link, a link to download.
Download link. Okay. So is there outstanding evidence that you have not provided to defendants in 3 years?
No.
Are you?
Well, frequently, Your Honor, I don't.
Is there any outstanding discovery that you haven't provided? No. Okay.
I have to talk to Mr. Doby to find out when this stray email must have been sent for me to download some additional body camera. It's interesting. I'm being told that much of it doesn't exist, which what I'm asking for is body cameras and dash cameras. And then in the same vein, being told 4 body cameras are sent to you. I don't know. I guess I'll have to look at them.
Yeah, that's a bit of a problem. It doesn't exist. Also, we've given it to you. Yeah, that doesn't seem right.
But I know there's lots of law enforcement that were involved with this. They're referenced in the police reports, and to be simply told they don't exist, I want to get some follow-up on here. I guess I'll have to file a motion to compel, and we can get evidence.com records to prove whether or not they exist and what efforts Mr. Dobie has taken, if any, to actually retrieve them.
Okay, I have a solution here, and Court of Appeals is down the road if neither one of you like it.
You know, right away you're off for a good time, right? The judge is like, I have a solution to this, and by the way, the Court of Appeals is down the street. If you don't know where this is going, you're not paying attention. Yep.
So today is the, what, 26th? No, yeah. My brain's already finished. Today's the 28th of January. Whatever's outstanding or whatever, can this be figured out by February 4th?
Oh, not that quick, Your Honor.
Why not?
Well, I currently have another.
Don't care. Because they have to come up with it, not
Okay,
you.
there's only one me, and I have lots of work.
I know you do.
So
I know you
that
do.
quick I cannot.
Wait a minute, you have a list of what you need, right?
Yeah.
Okay.
Well, I mean, I don't know what exists. By all police.
Not your job.
Yeah.
Not your
Yeah.
job.
Can this be solved by the 4th? No, Your Honor, I don't have the time. It's not a problem because this isn't your problem, right? The defense lawyers, there's only one of me. Can this be solved by the 4th? No. Well, I don't need anything from you because it's the state that has to give discovery. So I'm not sure why you're talking, defense lawyer. This has nothing to do with you. So I'm not 100% sure why you're talking right now. Love it.
Job. Sir, turn over everything that exists.
Yes, Your Honor.
You can
That's happened.
go through, it's gonna take 10 seconds. You could do it right now. I'm happy to wait. You can go through your email on your phone. Just don't say anything yet. You can go through your email on your phone, whatever, and look, and if you never received it, I'm inclined to dismiss this.
Well, that part we clarified. He gave me back in November a download with 172 files. We had a screenshot,
Okay.
and I confirmed with him that I have downloaded those, and that even in his own material, that those do not include law enforcement recordings. He's at least providing an update that there apparently he found 4 police videos. I don't know. He's never emailed or communicated with me about that. But if there's a download,
When did
I'll
you
download.
find those 4?
I'm sorry, I didn't find them. The detective sergeant now, I have no access to evidence.com or whatever the Lansing police use.
Oh,
But the additional 4 videos, so the entire reference 176 items. So sending everything again was sent this morning to Mr. Bear.
It was sent this morning. It was sent this morning. This would be why the defense lawyer doesn't know what you're talking about. What email? I don't know what you're talking about. We sent it this morning. Oh, really good on that discovery. Also, I really love how he's like, I didn't find it. The detective sergeant did. I don't know how to tell you this, but you're the government. You are one big government. And you and the police are bound by things like Brady. You're both so you are the government. I didn't find it. The police sergeant did. In this context, there's not really much of a difference between those two things. But we turned it over this morning, 3 years later. Super. And this is supposed to be the final pretrial conference. A little late on that one, aren't you? Yep.
Like within the last half an hour.
Oh, it's even worse.
so
It's even worse than that. Not only was it this morning, it was within the last half hour. Yeah, I wonder why defense counsel hasn't seen it.
So the 4 additional cameras were sent this morning, and I've received no additional information. Okay, now I understand.
okay.
Yeah.
Let me understand.
They didn't exist before this morning, apparently, Your Honor.
How long has this? Here's what we're doing. This case is dismissed.
I'm sorry, Your Honor. There's
Oh, look how panicked the prosecutor is. She says it's dismissed, and all of a sudden the prosecutor's like, oh no, I gotta do something.
There's been no motion to compel. There has been, you're dismissing these because only
I'm
because
dismissing these, so
Mr.
you go all
Barry
get your
says,
act together and you can reissue it. This file is 3 years old. This man is due a speedy trial, and this information is not new. I rarely do this. I can't think of one time in 22 years I have done this, but this seems to me to be unfair and prejudicial, and you can reissue. You can take your time and reissue when everything's put together, and then we're going to do all this again. And am I causing taxpayers money? Yes, but you know what? This man has been reporting to pretrial services for 3 years. The date
Your Honor,
of this offense
respectfully,
was-
he is
Yeah,
not.
respectfully, if you interrupt me again,
years.
you will be picked up and put in lockup for
Yeah, you tell him. The prosecutor's talking over the judge. You slap him down. You don't talk over me. You know it, Judge. I'm doing the thing called ruling. That's what I do. I'm the judicial branch. You're the executive branch. You can sit there and suck it while I'm talking. You say it, ma'am. Yeah. It's like, and also there was no motion to compel. Yeah, we don't necessarily need one of those because you have a duty already. You are already compelled. Have you heard of things like Brady? Brady said you were compelled. It said you were compelled long, long ago. There's been no motion to compel. But it's been 3 years. Screw you. Love it.
contempt. So I'll give you a chance to talk, but you will not interrupt me, especially when you're on Zoom, and I've given you the courtesy to not plow through the snow like everybody else, and you're on Zoom.
Yeah, that's not a great look. Everyone else is there in person, but not the prosecutor. The prosecutor couldn't be bothered to come down to the court in person. Woof.
This offense occurred February 15th, 2022, and I am not a judge who just dismisses things lightly. And you can ask everybody in this town, you can go down to the Court of Appeals, and you can do whatever it is you want. But this man has been under our charge for 3.5 years or so, and things have not been turned over until now, and now I'm hearing they need more and more time. There's constitutionally protected rights.
Yeah.
And you will get your, and there's no statute of limitations on a life offense. So when the Attorney General gets their act together, so will everyone else. This is dismissed for lack of progress and prejudice.
Nice.
My ruling, Court of Appeals down the road. Yes?
Can I make a record here, Your Honor?
You can make whatever record you want as long as it's respectful and don't interrupt me again.
Yeah, you already know that nothing you say is going to help. But if you want to say some stuff for the record, so sure. But the judge has ruled against you, and you can tell already the judge has absolutely no interest whatsoever in listening to anything you have to say at this point. Game over, man. Game over. But give it a shot.
Absolutely. Thank you. Yes, Your Honor. This case was charged by the Ingham County Prosecutor's Office. It was almost a year
I'm
before
sorry, you have to
the
stay,
AG.
sir, it's my court reporter, you have to stay near your microphone. The Zoom, for whatever reason, is not picking you up very clearly.
Thank you, Your Honor. This case was originally charged by the Ingham County Prosecutor's Office. It came to our office approximately a year after that. For about 1.5 years since I've had it, the defendant was on bench warrant status, not reporting. He is, despite repeated violations before and after that. I don't believe that there
What
is
violations
any
after that?
The court reporter can't hear him. It's clear. It sounds clear to us on the Zoom, but the court reporter can't hear him. So that's going to make it really hard to keep your record when the court reporter can't hear what you said. Woof.
I don't believe that there is any basis for
Hold on.
dismissing
Just a
this
moment,
case.
sir. It dropped after bench warrant status.
He's on bench warrant status, not reporting.
Yes, Your Honor. He was on bench warrant status following a violation. He was just on the idea that he has been reporting to pretrial services for 3.5 years. That's not accurate.
Well,
I
let
don't
me
believe
just
that there
say
is any
this.
basis for this
I think he's
dismissal
gotta start
based
again.
on the
Sir, you
defendant.
gotta start again. The court reporter's not making it up.
Your Honor, I don't believe that there is any basis in law for this dismissal based on the defendant's claim that there is additional discovery that has.
Well, it seems like a pretty good claim, to be honest, seeing as you just turned over magical discovery literally 30 minutes ago, 3 years into this. It's like, we want the body cameras. There are no body cameras. 30 minutes ago, oh, there are body cameras. Here are 4 of them. Yeah, it seems like there might be a bit of a basis for thinking you haven't turned everything over. Yeah, feeling it. Feeling a little bit.
Not been provided. There has been no order to compel, no motion to compel, and no.
I love that so much. There hasn't been a motion to compel. There hasn't been a motion to compel that we've defied. Yeah, there was an order to compel. It was filed about 60 years ago. It was called Brady. Go check into it.
Showing that there's been any wrongdoing by any party here.
Okay. The bench warrant that I have was in 2024. We are in 2026. The first witness list that I have here from the people was in 2024, August of 2024. This is a final pretrial. My expectation on a final pretrial is that you are all ready, not that we go back to square one.
That's a pretty good expectation, right? On final pretrial, everyone should be completely ready to go. Everything should be done. We should be set, ready. We should be cocked, locked, and ready to rock. And we've done discovery 30 minutes ago. Yeah, plus I don't really believe you that this is everything anyway. Yep.
Like when he was charged. And you certainly can file a motion for reconsideration or do whatever it is you want to me, but this is truly unconscionable here. In August of 2025, he was held in contempt and served 17 days. So between August and now January, there was plenty of time for this evidence and the files from both sides to get in order. I don't know why we're at final pretrial and now there's claims of things that have been in possession of law enforcement and the Attorney General and I suppose the Ingham County prosecutors for all these years and not been turned over. So as far as I'm concerned, a lack of progress is violating a fundamental right to presumption of innocence and freedom. And believe me, I don't do this lightly. I understand these are life offenses. They're very, very serious. But so is the lackadaisical attitude, maybe on both sides, maybe on all sides. I don't know, but I'm not going to stand for it. The resolution is to either file a motion for reconsideration or simply recharge defendant.
Love it. Love it. Yeah, the Constitution is still, in fact, a thing. The right to a speedy trial is still a thing. You've been fucking around for 3 years and you only gave discovery this morning and you're not really doing really good on the speedy trial thing. And you guys are screwing around between you. And by the way, again, you're all the government. So you get to inherit all the sins of your predecessors. I only got this, we're the AG's office. We only got this from the county prosecutor a year and a half ago. And as a judge, I'm like, I don't fucking care because you are all collectively the government. It's been state versus this guy the entire time. We've had different attorneys representing state, but it's been the same party, state, the entire time. So you collectively are the state. Congratulations, including the police officers. The police officers, local prosecutor, the AG's office, you are all collectively the state. And so I just got this case, ain't nothing, Chief, because you are all the same party. So eat it. You're defying the Constitution, plus several Supreme Court cases. Eat it.
No, we're done with this file.
Love it.
May I ask the court issue the order so I don't have to worry about an objection, 7-day rule and all that?
There's one right there, print it, we'll send it over to him and I'll sign it. Just do the blank one. I'm not.
Can I get that in writing? You sure can. There's one right over there. Just fill it out. I'll sign it. You can have that in writing. Excellent.
So, sir, I suggest you're not skipping town. You got another file in front of me. I suggest that you are the most law-abiding person on the planet. I don't like what happened here. I don't like these charges. I don't like this whole situation. But you do have a right to a speedy trial and a right to have an exchange of information that is timely. And this is simply disturbing. And I know everybody's busy. No one knows that more than me. And I have.
It's been 3 years, though. That's a lot of busy. It's been 3 years. That's a lot. And I'm here for it. This judge takes the Constitution seriously. I'm here for it. You go, judge. You go. You slap the AG around. The beatings will continue until morale improves. I'm here for it.
100% criminal docket. I get it. But this speaks to laziness on your part, your counsel's part, the prosecutor's part, the Ingham County prosecutor's part, and that's not a justice system. That's a lazy system. That's not what I'm going to tolerate. So message sent. They may very well reissue, so I suggest that you deal with your attorney and maybe you continue working on this. I really don't know. I'm not giving you legal advice, but they do have the option of reissuing this immediately, and they can do that. But message sent, I hope. That is all. I'm going to sign the order. We're going to, counsel's writing it. We're going to send it to you, sir, for approval, or I'll just read it now on the record. Can they put it in writing? I'll read it. I'm just going to read it into the record right now. Law. All right. This matter is dismissed without prejudice for the reasons stated on the record. Any objection to that, counsel?
No, Your Honor.
On behalf of the Attorney General?
None beyond what I've already stated.
Great. Send a message to your office. I expect timeliness, especially on the final pretrial. You all get your ducks in a row, or this will happen. I don't know what else to say. I have not done this in 22 years, but this does not sit well with me. Well, make sure you all get a copy of this. That's all for this record.
Thank you, Your Honor.
Law. And now the AG is just sad. Law. But yes, they can re-indict. They can re-indict. Yeah, the speedy trial right is usually not something you can dismiss with prejudice over, which is a bit unfortunate. Now, that being the case, however, in many cases, there might be a statute of limitations clock. So if the case gets dismissed, they may not be able in some situations to bring charges again because the statute of limitations has expired, because the case is dead. So they have to refile, but they might not be able to refile because the case is dead. So, and so forth and so on. Unfortunately, or whatever, this is life sentence. So, or this is a life sentence felony. So there's no limitations. There's no statute of limitations. And there is no double jeopardy issue because the jury has not been sworn, right? So double jeopardy typically doesn't apply until the jury is sworn, which obviously hasn't happened. So there's no double jeopardy issue. And so the typical remedy here is dismissal, or even if this had been even if there had been a trial with a guilty verdict and there had been discovery violations and the Court of Appeals found out about it, it's usually a new trial. So that's the typical remedy. And then if we're still within the statute of limitations clock, then we start all over again. And if not, then the case is just dead because the statute of limitations clock expired. But yeah, that's the typical remedy. So they may file their indictment again, literally tomorrow, but that means we start over, right? So the entire thing starts over. So unless he appeals and gets a reversal from the Court of Appeals. So if he goes across the street and seeks to reverse and the Court of Appeals reverses, then we pick up where we left off. Otherwise, we just start over all over again. But that's the typical remedy. But in any event, I'm here for it. I'm here for the judge dismissing this outright. And what was he charged with? The case didn't say. They just said it was a life felony. So I don't know what the charge was. But let's see if we can find what it was. So this is Ingham County. Yeah, hold on. Let's see if we can find out what specifically the case was. Ingham, Ingham County, Judge Aquilina. Dismissal of life felony. Let's see if we can find out. I don't see what case it is from a quick Google search, so I'm not sure. So unspecified what the charge was, but interesting nonetheless. Let's see if we can ask ChatGPT. Maybe it knows. Let's see if ChatGPT knows. How does it benefit the defense? Time is usually a major factor in favor of the defense. So because it gives them more time, that's usually a benefit to the defense. Witnesses sometimes become unavailable. They forget. Evidence sometimes becomes unavailable. So time is usually a benefit for the defense because things decay. So there's that. Plus, it increases the expense on the government to redo everything. They don't necessarily have unlimited resources. They have a lot of resources, but not necessarily unlimited. So they have to redo it from their end. So that's also annoying. I'm still not sure what the crime was. I'm still asking ChatGPT to look into it. They're still looking. Still looking. She was on the Larry Nassar case. That's where I recognize her from. Yeah. She was definitely gave Nasser some strong words as he's being hauled away. Are there safe harbor, savings clause, or tolling provisions? Sometimes there are, but none would be apparent in this situation. I can't think of what tolling doctrine would apply in this situation. So I don't think so. None of the AI programs seem to be able to find the case. Okay. Criminal charge. Yeah. It doesn't say. Yeah. Gemini couldn't find the specific case. Yeah, it's Carlos Lee Anthony is the guy's name. Yeah, can't find it. Can't find the specific charge. So our desire will remain unsatiated. So sorry, can't find it. So oh well. Anyways, I thought that was interesting. So I hope you all have a good one. Until later, my friends. Keep it good out there. Cheers, my friends. Until later, goodbye.